Hello. Sir, am I audible?
You're audible, ma'am.
Okay, thank you.
All right. So good evening, everybody. We all know that there is an increase in the rates of sexual abuses or sexual assaults that happens towards the people, and it is a need of the hour for us to understand that these kind of abuses or assaults are not gender specific in nature, neither are they age specific. So at this point, it would be totally right for us to say that these kind of assaults happen towards children also, and it indeed becomes a responsibility to address this social issue very carefully. So, in order to discuss the child rights against sexual assaults and sexual abuses, we have organized this webinar, and amongst us, we have Advocate Siddhi Mittal ma'am, who is an advocate in the Supreme Court of India, and we also have Advocate Rajneesh Madhok, who is a legal and a forensic investigator. So the format of the program or the webinar is as follows. We shall begin with the opening statements of our honorable speakers, after which they will be dealing with their topics of expertise, followed by a closing statement, and then we shall be taking up the question and answers from the participants. So I request participants, if you have any questions, you could just drop it on the chat box, and we will be taking that up in the last 20 minutes of the session. So, having said this, I would say we will shoot directly into the webinar. So, Siddhi ma'am, you may start with your opening statement for the session.
Hi, good evening, all. So today we've got a very interesting topic to talk about. It's sexual assault for children against children. Before we understand and we go in depth analysis of what is the topic actually, I would like to give a little brief about it. So when we talk about Pocso, to deal with child sexual abuses, we have a specific act. The government has brought in a special law, namely the Protection of Children from Sexual Offences, abbreviation Pocso Act 2012. The act came into force with effect from 14th of November 2012, along with rules framed thereunder. While I will be discussing the certain sections and implications of the act, I will also talk about rules that are framed under the act. So, when we talk about POXO and we talk about today's topic, I will give you a brief introduction of what all topics I will be considering in today's webinar. First, being introduction to POXO, I will talk a brief about what is the act, what are the principles, guidelines, and however. Then, general principles for the use of professionals and experts assisting the child pre-trial and during the trial. So, there are two stages we need to understand. When we deal with children, we have to prepare them for the trial, because obviously when we talk about POXO, we talk about children under the majority age. So we need to handle them with a lot of care. We need to guide them properly, and even during the trial, being an litigant lawyer, we have to prep them and what are the repercussions and how they have to present their case, because apart from legality, this topic really affects the child psychologically also. So we will talk about the general principles there. Then guidelines or statement under section 24 of the POXO Act, how a child is supposed to give statement, what are the guidelines for interviews and so on. Reporting of offense, who are the people who can report the offense and why is it necessary to report an offense. Then SGPU under Section 19. I will be discussing in detail that and various other POCSO rules. Then what is Child Protection Plan? CPP, I will be emphasizing on that because a lot of people are not aware about what is CPP and what are the guidelines the government has issued under the CPP, Child Protection Plan. Then what is free legal aid? Because when we talk about POCSO, we also deal with a lot of children, and because they come from a background where they cannot have financial assistance, they cannot afford a lawyer, so POCSO specifically deals about free legal aid as well. So we will be emphasizing on that for you to make aware. Then role of a lawyer of a child. So it being a lawyer, we have to be very crucial with the words we use in front of a child, whether we talk about sexual abuse, whether we talk about any kind of abuse, because there are various kinds of abuses. So we have to be very critical, very we have to choose our words very wisely. So the role of lawyers specifically before for a child, then victim compensation and rehabilitation under POCSO. So these are the topics that I would be covering in today's webinar. And thank you so much, De facto Jill, for giving me this opportunity. Over to Rajneesh sir for his opening statement. Thank you.
Thank you, Siddhi ma'am, for giving us your opening statement. Now, I would like to pass the baton over to Advocate Rajni sir to put forth his opening statement for the session. Sir, you'll have to unmute yourself. Sir, could you please unmute yourself? Could you just click on the icon next to the telephonic icon?
Sorry. Is it my voice is audible?
Yes, sir, you're audible. You may please continue.
Sure. I'm thankful to Madam Siddhi Mittal, the advocate of Supreme Court of India, Animesh Saurabh ji, and panel members Priyanshi ji, Nyanmoni Datta ji, Rahul Kumar ji, and I'm also thankful to Dr. Keval Patel, who could not attend this meeting due to his health problem. I pray to the Almighty for his early recovery. In addition to it, I am thankful to Madam Amulya Anil and media persons of this uh, organization who have conducted this sort of the webinar. Now the matter, the main point which we are going to discuss in this webinar is the sexual assault against children. So it is, I would like to mention the name of Jyoti Singh alias Nirbhaya. Nirbhaya, who was 23 years of age at that time, but in that, well, she was a physiotherapist at the and had been beaten, gang raped, and tortured in a private bus, and that matter could not be neglected at this moment because that matter has highlighted the problems regarding the brutality made to her, and the public gathered over that point, and the brutality has been brought into the notice of the public and the government, and another aspect which is more important in this subject is whether only POCSO is important. In addition to it, I will stress on the matter of juvenile defendants also, because in that case, the juvenile was a juvenile justice board. He got the uh, he could not get the proper investigation and got saved from the law due to his juvenility proposition. Now the another aspect which has been highlighted during these days This is that FIR delay not vital if rape victim from orthodox family. This decision has been made by Honorable Punjab and Haryana High Court because the FIR has been lodged about 7 to 8 months later after the existence of the occurrence of the offense. And now the Honorable Justice has provided relief to the affected party, and he has made aware that if there is any sort of delay due to the orthodox families non-awareness of the law, then it is not a serious offense, and very grave and serious offenses should be brought into the notice of the public. And now the topics those have been highlighted, which are being discussed over here, is Section 3 of Pocso Act. Section 3 of Pocso Act is the penetrated matter of offense, whether the penis has been penetrated or not. I will brought forward a case of a child of 3.5 years old child, and how that has been treated, and how the matter has been brought into the notice of the honorable court, and how the statement under section 164 has been recorded in that case. Secondly, the question is that whether punishment for penetrative sexual assault is only the factor which is being considered over here. No, it is not. Not concerned only whether it is penetrative sexual assault. It is when a person has inserted any sort of object above the undergarments, that will be considered as the penetrative objects, and that will be considered, and those persons will be prosecuted, and the foreign investigator will prepare the report on the basis of the investigation, that how he has concluded that this object has been made, and the penetration has been made like that. Now the role of the police, whether it is the prosecution witness or another kind of the witness, the question under section 376D, whether it is a gang rape, as the matter of Nirbhaya, it was a gang rape, and if such type of the incident occurred with the child who has having the age of less than 15 years, then how we will manage to brought it into the notice of honorable court? That is a matter of great issues, and it will be discussed in this lecture today. And it's section 362, 342, and 354 of IPC, which is concerned with the IPC, and whether this section can be added in this sort of the offenses made with the children. Yes, it can be, because section 8 and 10 can be is in addition to those sections. So the penetrative sexual assault and punishment thereof will be discussed in this webinar, and all those chapters those are concerned with this matter will be discussed later on. So I pass on the dice to another officiating person who will come on to the dice now.
Thank you so much, Advocate Rajni, for giving us the opening statement. And now I would like to pass the baton over to Siddhi Mittal ma'am to focus to move on to the second part of the session in order to focus more on the issues which she previously mentioned in her opening statement. Ma'am, please.
Very well. Thank you so much. Thank you so much, sir. It was a lovely introduction, and I will be looking forward your discussion. So now I will start explaining all the topics one by one, and then thereafter we'll be putting on questions. That's the format. When we talk about POCSO, like I mentioned, is protection of children from sexual offences, enacted in 2012 by the Government of India. It is a comprehensive law to provide the protection of children from offenders of sexual assault, sexual harassment, pornography, while safeguarding the interest of the child at a very early stage, if I may say, in the judicial process, by incorporating child-friendly mechanisms for reporting, recording of evidence, investigation, and speedy trial of offences through designated special courts. When we talk about Pocso, we need to be aware that the government and the Honorable Supreme Court of India had enacted special courts for fast and speedy trials. Moving a child. Now, what is a child? There are so many definitions, and if we talk about in general terminology, the Act defines child as any person below the age of 18 years of age and defines different forms of sexual abuse, including penetrative, non penetrative assault, as well as sexual harassment, pornography, and any act which deemed of sexual assault aggravated under certain circumstances, such as when the abused child is mentally ill or when the abuse is committed by a person in a position of trust and authority vis-a-vis with respect to the child or the family member, any relative, police officer. So the act bifurcates that very categorically in depth. Moving on, what do we understand by child abuse? Now that terminology, everybody has we have a separate definition. People have explained it very categorically. But how does POCSO defines child abuse? When a perpetrator is the person initiating this act. So when a perpetrator harms a minor physically, psychologically, even emotionally, sexually, etc., and neglects the act, is known the crime is known as child abuse. So, when we talk about child abuse, we wish to focus on specifically on child of sexual nature. Pornography, although it is covered under IT Act also, but POCSO also very categorically deals with sections with respect to pornography. Now, what can we include under child abuse? Fondling, intercourse, masturbation in the presence of minor, or forcing the minor to masturbate, obscene phone calls, text messages, digital interaction, producing, owning, or sharing pornographic images or movies of children, sex of any kind with a minor, including vaginal, oral, or anal, sex trafficking, any other sexual conduct that is harmful to a child's mental, emotional, or physical welfare. So now that we've discussed in depth what all the categories we come under sexual abuse, we can see that it is a very comprehensive law and it covers a very wider aspect under POCSO, and we are not limiting ourselves. So while enacting, the government has kept a lot of details in mind to see what all is covered, what all is not covered, and this is a very specific law. POCSO also casts the police in the role of child protectors during the investigation process. Thus, the police personnel receiving the report of sexual abuse of a child are given the responsibility of making certain specific arrangements for the care and protection of the child. So, the primary, apart from reporting the sexual offenses or the sexual assaults, if I may say, the Act also focuses on protection of the child and the child's welfare, overall development, so that it does not hamper the overall growth in the upcoming or the coming future in the nearby, because such acts really leave a lasting impact on the psychology of a child. So the police under this act has been told to make specific regulations, arrangements for the protection and the welfare, emergency medical treatment for the child, and placing the child in a shelter home is the primary concern. The police are also required to bring the matter to the attention of the Child Welfare Committee, popularly known as CWC, within 24 hours of receiving the report, so that the child, when we receive a report, does not is not left in those circumstances. Quick actions are taken. I would like the viewers to please mute yourself. Thank you. Moving on, the said act provides for special courts, the conduct, the trial camera. Like we say, in rape cases, we have only camera trial proceedings in rape cases as of now, but after this act, even Pocso's proceedings in litigations we see that are done in camera. No other person apart from the victim and the prosecutor or any other private litigator is allowed during that. Very limited, because the child is exposed to various questions, various situations where a lot of people will not be comfortable with. So that is why we have special codes for in camera proceedings, and without revealing the identity of the child. So we know that we are not allowed to mention the name of the rape victims. We call them prosecutress, and certain XYZ or any initial is given to them during the trial. So same is the case in child abuse cases. We cannot reveal the name of the child or the victim. That is against the law and it is a punishable offense. Hence, the child may have a parent or other trusted person as a local guardian or anything present at the time of testifying and can call for assistance from an interpreter, special educator, or other professional while giving evidence. So, while enacting these laws, our government, our courts have been very categorically not only emphasizing, I will keep on emphasizing on this point again and again, because apart from reporting, apart from making you aware about everything, our primary concern under the Pocso Act is to maintain and protect the child from certain circumstances, events where the growth is hampered. So I will keep on emphasizing on that fact. Moving on, very popularly discussed Section 39 of the Act. So I would like to give you a brief about Section 39. The Act recognizes almost every known form of sexual abuse against children as punishable offense. The Act is to be implemented with the active participation of the state governments. Under Section 39 of the said Act, the state government is required. Now, please take note, the state government is required to frame guidelines for the use of persons, including non governmental organizations. So, NGOs play a very important role under this act. We will be discussing the role of NGOs in detail in the coming topics. Now, what do they main focus on? Professionals, experts, persons trained in having knowledge of psychology, social work, physical health, and every etc. So there are a lot of topics that are being covered. We will be discussing. Moving on, what are the guidelines? So it is a multi-structural approach. We may say Pocso is not just a single-handed approach. It is a multi-structural approach. Children who have known sexual abuse are not only traumatized as a result of their experience, but are also more vulnerable to further and repeated abuse and at a risk of secondary victimization. Now, what do we understand by word secondary victimization? When the act has been committed once, it can be committed again. So, while protecting the child, we have to make sure that we provide him with such a shelter or such an environment where he feels protected, he feels secured, and is not victim to the second act of such a nature or acts of similar nature. The lack of clear guidelines till now and procedures on how to deal with child victims and their families in a child sensitive manner during the court process efforts, and the quality also, if I may say, I being a litigating lawyer, actually we come across a lot of procedures which talk about how the quality of law and lacunas that have been we've been facing affect the trial actually. So with Pocso coming in place, we have had an opportunity to have a multi-structural approach, and it has framed it has been very categorically specifically decided on all the aspects: how to interview, how to take statements, how to probably question a child, how a prosecutor to represent the case, how everything is being covered. Me and Rajnisa will be discussing that in detail in the upcoming topics. Moving on, am I audible?
Yeah, ma'am, you are right.
Yeah. Okay, thank you sir, because actually वो थोड़ा connection error हो रहा है बीच में. Hello. Hello.
Yes, ma'am. Audible. Please proceed.
Sorry, who actually वो बार बार reconnecting show कर रहा है. So moving on, discussing the guidelines and the principles framed under this model. We will be talking about the pre-trial, the post-trial stage, and even during the trial. Fundamental principles to be followed in the determination of a case involving a sexual offense against a child have been laid down in various international instruments and in the preamble of Pocso Act itself. State governments are given the liberty to form various guidelines individually, independently, as per the requirements. So the state governments, the Child Welfare Committee plays a very important role. The CWC, the special court, all of the government functionaries, as well as non-government organizations, and all professional experts assisting the child at the trial and the pre-trial stage. I will be discussing the principles now. First being right to life and survival. Every child has a right to life and survival and to be shielded from any form of hardship, abuse, or neglect, including physical, psychological, mental, or emotional. In the case of a child who has been traumatized, every step has to be taken to enable the child to enjoy the healthy development. Moving on, the second principle and the guidelines formed under POCSO is the best interest of the child. Whoever is arguing, whether a government prosecutor or a private litigator, has to have the best interest of the child. Every child has the right to have his or her best interest given primary consideration. This includes the right to protection and to a chance for harmonious development. Protecting the child's best interest means not only protecting the child from secondary victimization and hardship, but also to evolve and get him justice during the process because he's a victim and he has faced and seen a lot which can be traumatizing at a very early stage. So both the things have to be kept in mind, direct and indirectly both. Third being the right to be treated with dignity and compassion. So this is a fundamental right which has been given under the Constitution of India. Even a child who is a victim to anything has the right to be treated with dignity and compassion. Child victims should be treated in a caring and a sensitive manner throughout the justice process, taking into account their personal situation and immediate needs, age, gender, disability, and level of maturity, and fully respecting their physical, mental, and moral integrity. So even when the trial starts, we a lot of times we face that during the child gets sensitive, gets emotional regarding the situation, the things that are being discussed in the courts because he has to testify. He is the primary witness in the case. So even during that, we have to keep in mind that he should be treated with sensitiveness, with compassion, and not neglected. His emotions should not be neglected. Interference in the child's private life should be limited to the minimum need of information. The litigators and the police officers are very specifically told not to interfere in a private child's life, specifically girls, not to ask personal questions until and unless it is very important for you to know that relevant information. Now, fourth, the right to be protected from discrimination. In India, we face a lot of discriminations directly, indirectly. It's unethical. And for a person who is a victim of sexual offense, sexual assault, should not be treated as an individual that is untouchable. Maybe he is just one of us, he or she is one of us, and should not be a victim to discrimination. The justice process and support services available to child victims and witness and their family should be sensitive, because apart from the victim itself, the family also goes through a lot of trauma, so we have to be sensitive towards that as well. We have to keep in mind what is the child's age, gender, what are his wishes, what are the understandings. Because I recently come across a case where the child was of only 5 years and he was a witness to sexual abuse. He did not even understand what had happened. Uske according, all the words he could say was kuch galat hua hai. So we have to keep that in mind that what is his age, what is his understanding of the act, and with during those limited terminologies, limited understandings they could explain to a litigator or a police official, we have to give him justice. We have to be more sensitive and more empathizing towards the situation. Professionals should be trained and educated about such differences. It should not be a barrier to a child's rights to participate fully in the justice process. Now, the fifth, the rights to special preventive measures. Now, this is a very important one because this is not being followed on a very wider aspect and not much people are aware about it. So, in this, when we talk about special preventive measures, children already face twice as much risk of repeated victimization as adults because they often are to be perceived by a potential offender as being vulnerable, unsure of how to defend themselves, what to say, what not to say, and are unable to express properly. A preventive measure that could be used to protect children is to be demand references and criminal background assessment before hiring personals likely to work with children, such as school teachers. So, when I talked about NGOs play a very important role because now this is the place their role specifically comes. They have to give certain preventive measures. Specialized experts are to be presented in such fields while interviewing the child because not everybody can be that sensitive and not everybody can understand the situation. The right words, usage of words is to be given at that time. Right to be informed. Now, if right to be informed, there are two aspects of child victims and witnesses. Right to be informed. So, a child who's a victim and a witness are two separate things. Please don't ever merge that because then you will lose the main agenda before the justice process. The first aspect is the most general one and consists of informing child victims and witnesses about assistance they are entitled to, the way legal proceedings are organized, and the role they can play in those proceedings if they decide to do so. The second aspect is more specific and relates to information on particular case in which the child involved is it implies being informed about the process of the care, the post trial stage, about the scheduling of the proceedings, about what is expected from a child, the decisions rendered, etc. Moving on, the right to be heard and to express views and concerns. Now, instead of explaining each one of categorically, I will just name the principles and the guidelines under Pocso. The rights to effective assistance. This is a very general one. Like it says, the effective assistance should be given to a child to get justice. The right to privacy. This is the most important one, and I would like to throw some light on it because the child's privacy and identity must be protected at all stages of the pre trial and during the trial process. The release of information about a child victim or witness, in particular in the media, may endanger the child's safety because the child's intense shame and humiliation discourages him from telling what had happened and cause him severe emotional. During this, even the family support is really important for a child. For a person who is being subject to sexual assault, actually really needs support with the family, the relatives, the friends, because they have to encourage him to report the offense. And in order to get justice, in order to meet the needs, we have to be very supportive. We have to encourage so that the exact situation that had happened can be brought to light. And in the light of interest of justice, actual facts can be told. Now, moving on, the rights to compensation, which we will be discussing in detail. The child victim may be awarded compensation for his or her relief and rehabilitation. The compensation may be awarded at an interim stage during the pendency of trial as well as the conclusion of the trial. Procedures for obtaining and enforcing repartition should be readily accessible and child sensitive. Victims may be rapid and should be prepared for material losses and damages incurred. Medical assistance, psycho and sociological support to obtain reparation, ongoing and suffering. So when we talk about rehabilitation, we also have to talk about the development, the future that is to be governed of a child, because monetary compensations cannot always do justice. As per Section 33, Subclause 8 of the Pocso Act 2012 and Rule number 7, Sub Rule 3 of Pocso, so as to compensate with the short and the long term negative impact on the child, it is stated in Rule number 4 that the compensation is to be paid by state government from the Victims Compensation Fund or any other scheme to fund the establishment under the CRPC or any other law for the time being in force, and is absence of such fund or scheme, the state government has to make sure that the compensation is being rewarded, it's been given on timely basis, because we don't have to make him suffer on monetary basis as well. Moving on, the third aspect of today's webinar, guidelines on interviewing the child, how to record the statement, how to interview a child with respect to situations, how to ask questions, who can ask questions. We will be discussing this in detail. So there are two distinct aspects of gathering information from a child or attending any adult in cases of alleged child sexual abuse are A. Medical history, B. The interview. The interview stage of the assessment goes beyond the medical history in that it seeks to obtain information directly related to the alleged sexual abuse, for example, details of assault, including the time, place, frequency, description of clothing worn, and so on. Interviewing of children is specialized skills, if possible, should be conducted by trained professionals. In the context of POCSO Act, interviews may need to be conducted by a variety of professionals, including police or investigation agency. These are forensic rather than therapeutic interviews, with the objective of being to obtain a statement rather from a child in a manner that is developmentally sensitive, unbiased, and truth seeking, that will support accurate and fair decision making in criminal justice and the child welfare system. When we talk about interviewing, what are the reasons for interviewing the child? Now, some people have an approach that after the victim has been subject to such assault or the offense has been reported, please give him some time, please let him recover. But I think that is not a very correct approach. Like we talking about sexual offenses, they need to be reported immediately, because all the medical evidences can be collected timely, and after the expiry of 48 hours, the cloth can be not be recovered at certain cases. Medical examination cannot be very conclusive in certain cases. So that is why we have to interview the child at the earliest. Now, reasons for interviewing the child: to get a picture of the child physical and emotional state, how it is being affected, what is the physical appearance, koi injuries hai, what kind of injuries, what amount, and how depth are the injuries. So that is there. To establish whether the child needs urgent medical attention, to hear the child's version of the circumstances leading to the concern, because that is our primary evidence. When we interview a child, we need to understand that the first story that a child tells during the interview, after the case, is the very prime evidence, and that needs to be recorded very categorically, very sensitively by an expert. To get a picture of the child's relationship with the parents or family, this is to establish that whether the child the family is supportive, what kind of family environment the child is, what led to such act. To support the child to participate in decisions affecting from according to their age and maturity. This will vary from children to children. If I'm examining a person, maybe see, examination of a person with respect to 4-5 years, 7-8 years, and 13-14 years will be very different, and my approach to examine that individual will be very different. So that is also really important, to find out who the child trusts. So in certain situations, we really have to find a person who the child trusts. Reason being, a child will confide in such situations to a person. They will have They will find a person who they can trust, and they can tell the entire story to them, to inform the child of any other further steps to be taken in inquiry, and to explain them what is the process of the courts. That is the pre-trial stage. Now, what is interviewing setting? We have to have a certain guideline, certain criteria while interviewing the child, right? Not We cannot be very crucial about it, like on the spot we go and we just ask questions with respect to the situation or the kind of act. We need to maintain proper guidelines. So what are interviewing settings? And under the Pocso Act, the more comfortable the child is, the more information he is likely to share. Also, children may be too embarrassed to share intimate details when they believe that others can overhear what they are saying. As far as possible, interviews should be conducted in a safe and a neutral, child friendly environment. When we talk about sexual abuses, let's forget about other types of abuses for now, because today's webinar mainly talks about sexual assaults. Talking about sexual assaults is not a very comfortable topic for a child, be it male or female. It is not just subject to gender biasness. Even a male child will not be very comfortable talking about the sexual assault, the situation that he had been victimized to. So you have to have a very child friendly environment in that. The interviewer can incorporate elements to make a room appear child friendly, such as toys, art material, or as according to the age. So the government, when we are discussing this, you can see that the government has been very considerate while making the guidelines, the modules, and the guidelines to be followed during child interviews. They have very categorically and sensitively emphasized and focused on every aspect. Things to be kept in mind while interviewing a child. Now, not everybody can interview a child. First, foremost, please have clarity on that. A special expert only, maybe an NGO or by appointed by the court, can only interview the child. What are the certain principles that that person needs to have in mind? First, all children should be approached with extreme sensitivity, and their vulnerability should be recognized and understood. Try to establish neutral environment and rapport with the child before beginning the interview. For example, if the interview must be conducted in child's home, select a private location away from parents or siblings, so that even if the environment is not very child friendly, the child does not hesitate in confiding you, because sometimes the parents create a lot of pressure on children to disclose information. So you have to have a private corner even in home, away from the parents, relatives, so that the child feels secure. You have to build that rapport with him, so that he can talk to you about, or maybe confide in you, tell you honestly. Try to select locations that are away from traffic noise and any other disruptions. Even not legally, this act really covers the comprehensive aspects, because they have very categorically mentioned these model guidelines, which recently were introduced by this Honorable Supreme Court of India, to have established and have clarity on who can interview, what should they interview about, what kind of questions they should be asking. Always identify yourself as a helping person, and do not have any gesture, any expression in which you can pass on the impression that you are judging the child, maybe judging the situation. This will lead to the child not trusting you. They will not be very honest about it. They will not share the details because they will not trust you, and they will feel that you are being negative about the situation. So we need to be very clear with that. Ask the child if he or she knows why they have come to see you. They should be aware about their rights, firstly, but they should also be aware about the situations, what we have faced, what they have faced, what is right and what is wrong. Just because the parents or the relatives or somebody else, XYZ person, has reported the incident, does not really mean that the child will understand the veracity of the situation. So you need to make the child aware. You need to ask them whether they understand why they are being brought here. Then you can also Choose a location which is simple, uncluttered as possible, containing table and chairs. Avoid playrooms. Convey and maintain a relaxed, friendly atmosphere. Avoid touching the child and respect the child's personal space. Sometimes we feel that when you maybe have physical contact with the child, maybe touch them, pat them on shoulder, they will feel comfortable. But please make sure whoever you come across with, you have to respect their personal space. Not everybody is comfortable with you maybe patting on the shoulder, because they've just come across something very sexual and they're not comfortable even touching themselves. So we need to understand that, we need to acknowledge it. Like we said, it is not a gender bias law. You have to be very sensitive even with the female and the male, both children. However, subject to their you can say comfortableness, their vulnerability, you can carry on with the interview. But this can only, it is a very structural process. It is one step at a time. You will never have to talk about this again. You will never say the statement, everything will be okay. You will not make false promises. So, you will not, please keep in mind, never say this, never reassure a child by saying everything will be okay. You have to acknowledge the situation and tell him, we will be doing things legally, so psychologically, to make them okay, because you have to understand the situation and gain the child's trust. Moving on to the next aspect of the topic, medical and health professionals. Now, medical and health professionals also play a very important role while interviewing a child during their medical examination. Relevant legal provisions we will be discussing in the Act and the rules related laws. Now, Section 27 talks about the medical examination, which I will just read out to you. The medical examination of a child in respect of whom any offence has been committed under this Act shall, notwithstanding that the first information report, that is FIR, or complaint has been registered for the offence under this Act, be conducted in accordance with Section 164A of the CRPC. Second, in case the victim is a girl child, the medical examination shall be conducted by a woman doctor. Third, the medical examination shall be conducted in the presence of a parent or a guardian or any person that the child is comfortable with. Fourth, where in case the parent of the child or other person referred to in subsection 3 cannot be present for any reason during the medical examination of the child, the medical examination shall be conducted in the presence of a woman nominated by the head of medical institution. So this is the section 27 of the Pocso Act, which talks about medical examination. Moving on, what are the emergency medical care rules framed under the Pocso? Now, when we talk about medical emergency rules, Rule 5 is the rule that we have to deal with, which talks about SJPU, which is a concept we will be discussing in detail, which reads out as under, where an officer of the SPGU of the local police receives information under Section 19 of the Act that an offence under the Act has been committed and is satisfied that the child against whom an offence has been committed is in the need of urgent medical care and protection, he shall, as soon as possible, but not later than 24 hours of receiving such information, arrange to take such child to be the nearest hospital or medical care facility center for emergency medical care, provided that where an offence has been committed under Section 3, 5, 7, or 9 of the Pocso Act, the victim shall be referred to emergency medical care. So when we talk about, not all the lawyers are aware about rules under the Pocso Act, which are framed by the Honorable Supreme Court of India and the model guidelines. Under Rule 5, all the acts that are being covered, Section 3, Section 5, Section 7, Section 9, subject to any circumstance, you have to give the medical emergency care to the child. Now, what is emergency medical care? The child may be brought to a hospital for emergency medical care as soon as the police receives the report for the commission of an offence against the child. In such cases, the rule under the Pocso 2012 prescribes that the child is to be taken to the nearest hospital or medical care facility. This is reiterated in Section 23 of the Criminal Law Amendment Act, which inserts Section 357C into the CRPC 1973. This section provides that all hospitals are required to provide first aid or medical treatment free of cost to the victims of a sexual abuse. Medical examination. Now, when the medical examination is conducted of any victim, there are certain guidelines that are being framed by the government, by the Honorable Supreme Court of India, that how a medical examination is to be conducted. Section 27, like we mentioned, talks about this with respect to Section 154A of the CRTC, where during the stage when an offense of committing rape or attempt to commit rape is under investigation, it is proposed to get the person of woman with whom the rape is alleged. Now, please have very categorically, emphasize on this word, whom rape is alleged or attempted to have been committed. So not only just a confirmation of an offense, even if alleged allegations are there, you have to examine by a registered medical practitioner employed in a hospital run by a government or the local authorities. Registered medical practitioner to whom such woman is sent shall without delay examine her and prepare a report of her examination giving the following particulars, namely, first, the name and address of the woman and of the person by whom she was brought. Second, the age of the woman. Third, the description of material taken from the person of the woman, DNA profiling, marks of injury, if any, the person, general mental condition of the woman, the mental state, other material information. We will not be discussing much about the modalities and the models formed under this, but I would just like to mention under this uh, head, medical or the health history has to be taken care of. Uh, Even in the section 27, we have very specifically said the medical history is to be taken care by the person medically examining the child of the sexual abuse, and the report in which they prepare, they have to mention all of that so that the person dealing with or the litigator or the police investigator knows what the medical history is, whether the person has been sexually involved in past or not. For instance, this is an example. So now when we talk about victim compensation and rehabilitation under Pocso, this is a very important topic. Like we said, we will be covering this in the separate topic. Now, what is compensation scheme for women victim survivors of sexual assault, other crimes 2018? This is a very new scheme that was introduced by the government of India, issued by National Legal Services Authority, where a minimum amount of rupees 4 lakh and a maximum amount of rupees 7 lakh is to be provided for to the victim. In a sample study conducted by the Delhi Commission for Protection of Child Rights, a statutory body constituted under Section 17 of the Commission of the Protection of Child Right Act 2005, it is specifically said that the study highlighted the challenges of faced by child rape victims and their families face aspects that have been defined bearing on their rehabilitation, social reintegration. An analysis of the study revealed the following. First, 42% of the child victims dropped out of school. 50% of the child suffered from different types of physical illness that were linked to rape. About 81% of parents stated that they were unable to fulfill the health needs of the children who were victims to child rape. Third, with regard to compensation, the study revealed that only one child had got compensation of more than 50,000, whereas 99% of the children had not got compensation as per the prevalent scheme. Section 38, Clause 8 of Pocso provides that in appropriate cases, in addition to the punishment, the special court may direct payment of compensation to the child for any physical mental trauma caused to the child or for immediate rehabilitation. Pursuant to the Parent Act, Pocso Rules 2012, Rule number 7, to the procedure and parameters of providing such compensation. With this, I would like to conclude my today's webinar. The other topic I would be regarding the free legal aid of procedure, that is with respect to the litigation, I will be holding and maybe concluding in my conclusive statement. Thank you so much, and we'll be looking forward to your questions.
Thank you so much, Siri ma'am. It was indeed a very enriching and quite elaborative sessions, and I hope the participants have a fair idea about the things which they perhaps did not know earlier. So, with this, I would like to put the baton in Rajneet sir's court. So, Rajneet sir, you may please proceed with your topics of discussion, and we're looking forward to hear you. So, you'll have to unmute yourself. You're audible now, so please proceed.
Thank you, Amulya ji. The matter with regard to sexual offences against children, if we come to the main aspect, that is penetrative sexual assault and punishment thereof. The first and foremost part of this discussion is that Section 3 of Pocso Act is regarding the penetrative sexual assault. Will always be read with Section 6 of Pocso Act. A person is said to have penetrative sexual assault if, kindly go through the definition of the section, he penetrates his penis to any extent into the vagina, mouth, urethra, or anus of a child, or mistakes the child to do so with him or any other person. The point of more importance is that हिंदी में बताऊंगा कि वह अपने लिंग को किसी हद तक बच्चे के योनि, मुंह, मूत्र मार्ग या गुदा में प्रवेश करता है. It is not like that. If we go through the details of this section, that we have to create so many hurdles in this section. The prima facie indicating towards the commission of the offense under Section 3, read with Section 6 of POCSO. Charge under Section 6 POCSO is liable to be framed against the accused. इसके बारे में मैं कहूंगा कि बच्चे के योनि में, मुंह में, मूत्र मार्ग या गुदा में प्रवेश करना ही उसके इसमें एक सफिशिएंट कॉज नहीं है. इसके साथ में और भी बहुत से आपराधिक तत्व हैं जिसको कंसिडर करना चाहिए. He inserts, next question is that he inserts to any extent any object or part of the body not being the penis into the vagina, the urethra or anus of the child, or makes the child to do so with him or any other person. The next point is that he manipulates any part of the body of the child so as to cause penetration into the vagina, urethra, anus, or any part of the body of the child. Now we come to the example to this aspect. There is an example. The age of the victim was 3.5 years old only. The victim was bathing in the rain at her terrace. The respondent accused, who is neighbor to that victim, was also taking bath on his terrace. He agreed to have called the victim and was allegedly giving her a bath. When the complainant was taking the child victim down the staircase, he kept the child downstairs, and she informed the mother that the accused had removed her undergarments and had touched her inappropriately. Now the question arises that how we will collect that information from a child of 3.5 years old only. The complainant informed the husband and police called. The FIR got registered. MLC of the victim conducted next day of the morning. Now the question is that whether local examination of the genital parts had been made, opinion of the doctors in MLC has been collected. Now how the questions and answers will be put to the child of 3.5 years old child. I'm giving you the example that how we conclude and how we take the information from the child. That statement is covered under section 164 of criminal penal code also. First question we put to the child is that, do you like bathing in the rain? Obviously, the child will say that yes. The next question is that, was there anyone when you bathed in the rain? She told us, yes, that was Raju. Then the next question is that, how did you bathe? She told that Raju was doing like this. The child rubs her vagina continuously with her hand. That was the main point by which we concluded that the matter is sensitive and it should be brought into the notice of the court. Then we asked what happened. I asked him to leave. She said that I asked him to leave. It means that there was something special that she forced the person who is accused to leave the space. Then did you tell the incident to anyone? She told that yes, I told to my mother. Then she told, we asked that do you tell anybody else also? She said that yes, I told to my dad also. He was on the terrace at that time. Now the question arises that in this statement, we recorded the statement and FIR has been lodged under and the statement under section 164 CRPC has been lodged, and the point that he has rubbed her vagina continuously with her hand, it puts that there was something wrong, and then the part was directed to the MLC for further examination. The MLC report indicated that there was redness over the posterior force. Posterior force check, if you go through the terminology of the medical ground, then it is called thin fold of skin at the back of the vulva. It means that there was something which was punishable under section 3B of the Pocso Act, that he has inserted such type of the material in her body, and that is coverable under section 3B of the Act. So the section 3B of Pocso Act has been applied to that in that case, and the penetrative sexual assault has been registered in that case. Now the question is that whether the undergarments had been removed or not. This is not a question whether undergarments had been removed or not. The person who has been collecting the investigation report, he found that this is the grave suspicion, and this can be treated as the alleged offense. Now the MLC report came on record, and what MLC report had been said that there was a grave suspicion, and the section 6 of the POXO Act should be applied on in that case. Now the question is that whether punishment for penetrative sexual assault has been made. Yes, we will conclude that this is the aspect, and the penetrative sexual assault has been made in that case, because she has rubbed her vagina with her hand. Now, what is the description regarding the punishment in that case? It is not less than 10 years, when the and it can be extended to the life imprisonment also. Now we come to the point of penetrative sexual assault with a child having the age of 16 years of age. Yes, we will conclude that when a child is less than 16 years, or it is in the 16 year age, it would be considered as it would be considered as the punishment for penetrative sexual assault, and the victim will be penalized in that case. Now, section 6 of the POXO Act calls that imprisonment for a term which shall not be less than 20 years, but which may extend to the imprisonment for life. It is also a matter of great concern that this is the subject which we brought into the notice of the Honorable Court. Now it is now we can say that all the offences are not being made by the majors also. The offences may be made by the person who is juvenile. Then whether the person who is juvenile, whether he will get the bail in that case, it is not sure that the court will allow the bail to that in that case. Now the next question is whether Section 10 of Pocso Act punishment for aggravated sexual assault will be considered in that case. In that case, if we consider that aspect, then the sentence will be extended to 7 years of punishment. Now, Section 12 of the protection of children from sexual offences, we will consider that punishment for sexual offences is that the imprisonment of either description for a term which may extend to 3 years of punishment. Now, we will discuss the matter of juvenile justice. Whether Juvenile Justice Care and Protection of Children Act 2000 should be considered in this case. Yes, Juvenile juvenile's cutoff age is 18 years. Ministry of Women and Child Development several times have made representations and desired amendment in this case. But the amendment in this case to lower the case of juveniles from 18 years to 16 years has never been made, and the Honorable Supreme Court has dismissed the demand for reduction of age of juveniles from 18 to 16 years. Now the question is that if the offense has been made by a juvenile, whether he will get the bail in that case. Now the question is that it is a bailable or non-bailable offense. The question arises that why the court will deny such type of bail to this to the juvenile. The matter is that why it should be denied when he shall not be so relieved if there appear reasonable grounds for believing that the release is likely to bring him into association with any other criminal or expose him to a moral, physical, or psychological danger, or that his release would defeat the ends of justice. It is sure that if there are another sort of the offenses, those are connected with that juvenile, then the bail will not be granted to that juvenile. Now, whether we can implicate that person in with regard to the kidnapping and abducting of in order of murder, yes, under Section 364 of IPC, kidnapping or abducting in order to murder can be added with regard to Pocso Act, and that's the imprisonment for life and up to 10 years of imprisonment will be made to him. And now the question is that whether 500 Section 506 of punishment for criminal intimidation can be made. We see that most of the time the criminal intimidation that आपराधिक धमकी दी जाती है, the person has been always been made the offense like criminal intimidation, and the imprisonment for that case is extended up to 2 years or both of the cases. Now, in this case, the Juvenile Justice Board of Jagadri just now concluded and in this regard has denied the the bail to the juvenile on the ground that although he is 16 years of age, but the case is which is not related to the reasons, though those are presumptions. The courts presume that if the juvenile is released on bail, he may be exposed to moral and psychological danger, and his release would defeat the ends of justice. That was the main cause that why the bail has been denied to that person. Now the question is that whether these sort of the cases can be concluded and the criminal case can be registered against the person. Yes, because the bail can be denied because criminal case has been registered against any of his family member. If any of his family member has been involved in any sort of the criminal case, then the honorable judge will not provide bail to the person who has applied for the bail on the juvenile ground. Now the highness heinousness and seriousness of the offense will be taken care of. Whether he has made any offense, whether under section 12 of Juvenile Justice Care and Protection of Children Act 2000, he will be granted the bail. No, he is not. He should not be granted bail because he has made the offense which can be described as moral, physical, or psychological danger to the public, and those facts should be considered, and on those factors the bail to section to the juvenile could not be made under section 12 of Juvenile Justice Care and Protection of Children Act 2000. Now the question is that whether the intention of the legislature is to grant bail to the juvenile, though it is permissible that all the persons who are involved, those are less than 16 years of age, can get automatically bail. But in the special cases, all those grounds and reasonable grounds of denying bail can be accepted, and the moral, physical, or psychological danger should be considered before concluding under this section. Now the nature of gravity of offense. Nature of gravity of offense is to be treated whether the person who is juvenile. Now we come to the case of Nirbhaya. Nirbhaya has in that case the one person has completed the age of 17 and 6 months. Whether we should treat that as a juvenile, yes, it has been treated as juvenile, but the public has opposed, and in that shape so many assemblies have been made in that factors and opposed that factor. Now the question is that under Pocso Act, what are the points those are considered as contradictions in testimony, and whether it is illiterate lady, whether the parents of the prosecutrix have been examined or not, whether the prosecutrix are minor and belongs to scheduled caste or scheduled tribes. These factors are to be treated, and the sexual offences under section 6 of Pocso Act will be considered as rape and will be treated along with those factors also. Section 6 of the Pocso Act is regarding the rape, and now the question is that whether all the mother and father was investigated and the statements of those have been taken or not. In most of the cases, the courts have denied that if the statements of mother and father have not been made, then it will not be treated that the offense has not been made. Now the question is that whether the rape is clear and unequivocal testimony has been made. Prosecutrix will define that how this sort of the action has been made. Now I come to my part, that what is the role of a forensic science laboratory in this case. Now the forensic science laboratory will collect.
Sorry to cut you, sir. Before we proceed towards this question, since Siddhi ma'am has to leave the webinar a little early, I would request that we first hear a closing statement, and we have two questions for her. After that, we will get back to you, sir. Thank you, sir. Thank you so much. Siddhi ma'am, for your closing statement, please.
Yeah, hi. I am really sorry, sir. You have to be interrupted in such a short way. Today's webinar was really informative, sir, and you have covered various legalities with respect to sexual assaults with respect to children. So, for my closing statement, I would just like to say that this is a very sensitive topic, like we've all discussed regarding the legalities and the psychological aspects of this topic. One needs to be well aware because lot of people are not aware all the laws which are coming day by day, because this is a very dynamic field and it is evolving day by day. Now, when we talk about child sexual abuses, not a lot of families acknowledge circumstances. So I would just like to conclude this by saying that we need to spread awareness as much as possible with respect to this. And thank you so much, Animesh ji, for giving us this opportunity for talking about such a sensitive topic and such a vulnerable topic in today's aspect, because a lot of people even in our profession are not aware about the procedural aspects regarding the POXO and the minority ages and the legal rights of a child. So thank you so much, De facto Jill and Amishi, for giving us this opportunity. And now we can proceed to questions, if any, please.
Okay, so ma'am, just a quick two questions. The first question is one of our participants wants to know if the acts we have discussed are gender specific by any reason. And the second question is if you could brief out about how the child protection plan comes into the picture. So, yeah.
So while talking about POXO, actually, if I may say, our laws are very gender biased per se. When we talk about IPC, we talked about Sexual Harassment and Workplace Act, but POXO very specifically is not a very gender biased act. It talks about a child, not a female child per se, not a male child individually. It talks about overall. Although there are certain provisions which have been very specifically decided in certain circumstances where a girl child is involved, because other exceptions are there and other things are to be considered when we talk about girl child. But it is definitely not a gender biased law. It's a very neutral law, and we have to evolve our law day by day. So it is an evolving law. But I think that it answers your question that it is not a gender biased law.
Thank you, ma'am. The second question, ma'am, was how the child protection plan would come into picture. So, if you could just briefly answer this question in a minute or two.
Yeah, sure. So when we talk about Child Protection Plan, popularly known as the CPP, so as stated in Rule 4, Subclause 7 of the POXO Rules 2012, the CWC, which is the Child Welfare Committee, on receiving a report under subsection 6 of section 19. अभी रजनीश सर डिस्कस कर रहे थे सेक्शन 19. So section 6 of section 19 of the act, or on the basis of its assessment under, a report is to be formed. And sub rule 5 also talks about the formation and the guidelines of such report, what is to be included, what is not to be included, with the consent of a child, a parent, his or her parent, the local guardian, or any other person with whom the child trusts or is in confidence with. So when we talk about child protection plan, it is to support and re-establish the child in today's society, overall development after the child has faced victimization. The child protection plan, in respect to the child's rehabilitation, also talks about providing them with a shelter home, such a protected environment which in which the child, after the incident, can talk freely to counselors, can also talk to various other experts with respect to their social needs, their emotional needs, their physical needs. Because in certain cases, apart from psychological needs, we all have to recover physically as well. So child protection plans also includes such needs. So briefly, I think I can explain CPP in this format only. Rule 5 of the child protection plan of the POXO rules, I'm really sorry, talks about this. And if you want me to explain this further, you can please contact the organizer or take my email ID or the email phone number, and we can discuss your questions in detail. I'm really sorry, I have time constraints today. I had a meeting. If any other questions, I am here to answer.
So these are the questions we've had till now, ma'am. But like you have mentioned, if there are any coming after a few minutes, we shall be forwarding it to you via emails or whichever mode of communication is deemed convenient. We are really happy to have you on board, and it was very enlightening and rather a very enriching experience to hear your views and most importantly to hear the practical aspects of how to deal with a child abuse case. So with this we express our gratitude towards you, and the founder of De Facto Gel Animesa will be contacting you soon after the session for your feedbacks and further communications. Thank you so much, ma'am, for your time.
Thank you so much. Thank you so much, Team De Facto Jill and Advocate Rajneesh Chaudhary for having me. Thank you, Rajneesh,
Thank you, ma'am. Thank you, ma'am.
Thank you, ma'am.
for sharing the platform, and it was an honor to listen to you. Thank you, sir. I'll be taking your leave now.
Yeah, thank you, ma'am.
Thank you, ma'am.
Coming back to you, we really thank your patience and sorry to cut you in the in middle again. And we would like you to proceed with your topic and discussion from where we had left before.
Thank you, Amulya ji. Whether my voice is audible?
Yes, sir, you
Hello.
already please proceed.
Now the question is that what forensic science laboratory report how we make this report and how it is beneficial in the case of the rape with the child. Now the first and foremost question is that the semen is being collected from the clothes like salwar or skirt of the child and with the from the undergarments of the child. Now the second question is that the second point is that the fact that the prosecutrix is minor has been established on record. We should make it mandatory that whether the prosecutrix is a minor, and those factors should be brought into the notice of the honorable court. And third point is that facts the victim belongs to scheduled caste, scheduled tribes, or to the general category. Those factors are so much important that because the action again with regard to SC/ST Act will be taken against the accused also. And next point is that prosecution has proved the case beyond reasonable doubt. That is the point which is to be considered. Now the basic ingredients by which we conclude in so many cases that what is the procedure that how we conclude that punishment that is a case with regard to punishment under section 376 subsection 2 subsection I IPC, that is that commits rape on a woman when she is under 16 years of age. The minimum imprisonment in that case is 14 years, and the fine will not be less than 10,000 rupees. This is the sentence which is considered more important, and the imprisonment in that case is more than the permissible limit of section 4 of Pocso Act. For protection of children from the Sexual Offence Act, the maximum sentence in section 4 is 10 years. So now we conclude that we will bring to the notice of the honorable court that 376 2 subsection I IPC has been committed in this case. The next question is that whether the child the child who belongs to SC or ST SC, then the section 3 of SC/ST Act will come into force, and 3 years imprisonment, rigorous imprisonment in that case is also permissible, and rupees 5,000 penalty can also be imposed in that case. Now forensic investigator report, how we conclude that with regard to the forensic investigation. Number one, the point is that complainant prosecutrix name be withheld to conceal her identity. We will not provide the knowledge of the name of the prosecutrix it should be concealed in every cases. Neither the name of his mother, neither the name of her mother or father will be brought into the notice of the public. Okay, the all the family members of the members, those visited to the police station, those will not be brought into the notice of the press also, and to the notice of the public also. Second question is that the point is the recorded statement to police in presence will be made in the presence of legal aid counsel. Without the presence of legal aid counsel, the statement cannot be will not be recorded. Secondly, the age of the complainant prosecutrix in which the class in which class she studies, left studies, or doing any sort of business job, it should be brought into the notice of the police department. Next question is that whether the specific child is married or unmarried, because there are so many cases when the marriage has been conducted to the adolescent child. Now the date of occurrence of offense and time of offense is to be noted. It is to be noted, and that should be brought into the notice of the police also. Next question is that where were the mother and father of the victim at the time of occurrence of offense? Hello, hello. Whether my voice is audible?
Yes, sir, you're audible. Please, sir.
Now the next question is that where were the mother and father of the victim at the time of occurrence of offense? Now the question is that if how will we will conclude that mother and father was not there at the time of occurrence of offense, and where were they at that time? Next question is that why the prosecutrix complainant had gone to the place of occurrence of offense. It is a very important point that why the person has gone to the place of occurrence of the offense. Now, next question is that at that time the prosecutrix at what time the prosecutrix left home and reached the place of occurrence. That is the main point, because that should be considered when we take the position uh, of the adolescent, and the procedure will be accounted for. Next question is that whether the place of occurrence was in the field or in the house. The prosecutrix complainant was known to the exact place or not. It is whether the person whether the prosecutrix if she has not having the knowledge about the address and the location of the particular place, then from which place and from whom she has inquired about the address of that particular space place. Now the next question is that what was the purpose of prosecutrix to go to the location? Now I'll bring to the notice that why there is an example why the prosecutrix has gone to that place. It is connected with a girl child who had gone to deliver the meal to her mother who was working in the fields. So she had gone to the fields to deliver the meal to her mother. Now next question is that uh, when at what time the prosecutrix was taking meal to her mother, for example 10:30 a.m, 10 a.m, 10:15, the exact time of the place when he has gone to that place and left the place of her residence. Next question is that exact location of the fields was known to her. Now the prosecutrix to know the location of the field, she intentionally has not put the question to any other person. son, but the exact location has been told to him by someone who was nearby at that place. Who was that place? It should be brought to the knowledge of the court, and whether it was a particular place or she was misled by anybody to go to that place. Now the next question is that someone has told her that that location is at that place, but that person has misled the prosecutrix. Then what will be the consequences? The the person who had misled the child, the prosecutors reached to that field afterwards, but the person who has committed the rape, he reached that place prior to that child. And what he made, that he gagged the mouth of the child and put chunni in her mouth, and committed the offense of rape. And consequently the incident of rape had been reported in that case. And how he got investigated, and how this matter was brought into the notice of the honorable court. Then this question is that on next date, as she was suffering from fever, on being asked by her aunt, she disclosed the incident to her. This the person now the matter, how the matter got reported to the police. The matter got reported to the police, and the FIR, how the FIR has been registered. These one by one, all the points should be brought into the notice of the police, and the investigation report will be brought into the to the police. After the prosecutrix will be produced before the magistrate, and the statement under section 164 of the criminal penal code will be recorded before the magistrate in whose jurisdiction that offense has been made. Now the question is that when the accused had been arrested, medical examination of the accused had been made, and from which place it had been made. Now the next point, that the site plan of that the site plan of the occurrence of the crime will be made, and that will be brought into the notice of the court, with including the statement of the witnesses should be recorded in that case. Now the samples, what sort of the samples are to be collected, and what sort of the samples are to be sent to the laboratory. Those sort of the samples, like medical examination reports, will be for medical examination report and a chemical examination. The samples will be sent to the forensic science laboratory, like in our we at Punjab and Haryana court, the nearest possible investigation authority and forensic science laboratory is situated at Madhuban, and all those samples are being sent to that place. The prosecution will be examined with a number of witnesses in its reports. Now the statement of accused under section 313 criminal code will be recorded. Then what has been brought to the notice, that he will say that the Salwar was the question of the person who has committed a crime. He will come to the court and record his statement. Obviously, he will say that the Salwar, which was recovered by the police on the date of occurrence, it is belonged to his wife. The color of that salwar was saying that either it may be brown or it may be green. That will be pointed out to the honorable court. Now the situation is that how the prosecution witness will come to the court and how they will be examined. Now the prosecution, how we conduct this sort of the cases. The prosecution case, the prosecutrix, how he deposed. First of all, she will tell that my date of birth is so and so. I was studying in such and such class, and at this date I had joined my school, and on that date I took admission, and that will be considered that how the accused had committed the crime. He will provide that I had gone to the fields to provide the food to my mother, and at around 10:30 I reached the specific space, and on the when I asked the specific location, the accused had pointed who was standing on the roof. He asked me that your mother has gone to this particular field, and he disclosed that intentionally sent her to another field, and as there was a cotton crop which had been in that field. As soon as she reached there, he forcibly caught hold of her, and forcibly broke the string of the salwar, and when she tried to raise the alarm, he gagged her mouth and dupatta and ravished her. This was the case, and now the question is that whether she was got threatened in that case. She will admit that yes, she had been threatened in that case, that this incident should not be brought into the to anybody. Then the question arrives that where is the tiffin. She will say that she has thrown out that tiffin in the field when she could not find the mother of her mother in working in that field. Now the inquiry and the disclosure will be made the next day. What will be done? The statement will be recorded, and that statement will be made in the presence of lady advocate. It should be considered that one should not the statement of any person could not be made without the presence of the without of the lady advocate, and in the presence of the lady police also. The signatures will be put on that statement, and that points will be marked as point A, point B, and the medico legally examined report, which will be sent to the general hospital, will be considered at the time of reporting to the police. And now the cross examination of the victim. How we cross examine if we are on the opposite side. The question the question will be put before the victim, that is that we will say that you are not 16 years, but you are more than 18 years of the age at the time of incident. How will you conclude that you were 18 years of age? Then obviously he will bring into the notice of the court that she is 18 years of the age, and she will bring to the notice of the court. This is a very important factor, and everybody should know that this factor will be disclosed in the court. And next question is that how much is the distance between your house and the place of occurrence? He will obviously say that there was a difference of about 7 kilos or 8 kilos from the house of her own, and to the place of the occurrence of offense. Now the next question will be put before her, that whether that particular place is situated in the nearby fields, or it is situated nearby abadis. Now the question is that she will disclose that yes, it is nearby Abadi, and then the question arises that why not you raised the alarm at that time when you was nearby Abadi. Now the next question is that whether any sort of the crop has been cultivated in that field or not. The question is that yes, the crop was cultivated, and it was a cotton crop that was cultivated in that area, and that was grown up crop. Now, if that the grown up crop was that, and it was where was the situation of that field, that it was told that she will tell that he dragged me and from her hand, but he could not resist because the tiffin was in her hand, and he could not raise so much alarm because now the question is that whether she got injury marks from the crop when she was dragged, whether your clothes were torn out when you were dragged in that field, and that if she was dragged from the drain, whether her clothes were smeared or there were blood stains on her clothes or not. Those questions are very important because most of the cases, or when the cross examinations are is being conducted, most of the accused could not face the trial, and all those accused may get could not be convicted in those cases. Now the question is that why not the injuries had been made when you were dragged and when you were holding a tiffin in your hand. Now, next question is that whether she was the place where she was ravished had cotton crop where it was damaged, whether the crop in which she was ravished, whether it was damaged or not. This is a very important question. If she says that it was not that crop has not been damaged, then it means that the incident has not occurred. So all those factors, that she was gagged, she was dragged, and she was and one hand was in her mouth, put by the accused. Then at that time, in that particular case, the color of the salwar, kameez, the clothes, whatsoever she has had been worn, she will provide the information that she had sustained injuries or not. If she had got the injuries, then the injuries should be marked in the MLR report, which has been conducted, and the investigation report, MLR reports, which has been brought into the notice of the court. Now the next question is, and where was in the surrounding fields, whether there was persons or not. She
So
will definitely say. She will definitely.
running out of time, so I wish if we could, wrap up this session between the next 10-15 minutes, then it would be really helpful for us so that we have sufficient time for the question and answers as well.
Thank you. Thank you. Thank you. Now the I am concluding that chapter, that how these factors will be brought to the notice, and how these factors will be how such and such incident occurred, that will be brought to the police also. And next question is that government primary school where she studied, those documents should be brought to the notice of the court, and those document with the admission register, and when she withdrawal from the government primary school should be brought into the notice of the court. Otherwise her allegation will not be proved in the court. So the next question is that who will provide the knowledge about the site plan of that particular area. Patwari of that area will brought to the notice to the and he will provide the site plan, including the size of the karam. For example, 40 karam is equal to 1 inch. That site plan will be provided to the investigating officer, and during cross examination he will be put that how you concluded that this was the field where the crime has been put before has been made. Now the question will also be put to him that whether the crop of cotton has been which has been destroyed or not. Obviously, he will say that the crop has not been destroyed. Then the Gardavari and Khasra numbers will also be provided to the court that this is the thickly populated area or not. The next question is that the police will come to the court with the affidavit with regard to the offense, and investigating officer will depose before the honorable court. Next, the doctor will depose before the honorable court, and the clothes of the persons of the victim will be put into the seal, where all those documents will be brought into the notice of the honorable court. Blood samples, those have been collected from that particular a child will be collected, and those have been collected would have been sent to the laboratory concerned. And the most important point is that pubic hair in glass vial will be collected, and that pubic hair, including the swab in glass vial, will be sent to the laboratory concerned. And in and all those documents, papers, those collected from the site of the occurrence of the offense, those will be sent to the laboratory in sealed cover, and those documents will be provided to the court with all those aspects. And next question will be the head constable and all the constables, and secondly the all sort of the persons those have done the investigation, the Patwari's report or the DC office report regarding the gadget notification, whether she belongs to scheduled caste or not. All those factors, those have been brought to the notice of the investigating officer and the Ilaka magistrate also. So the recording of the statement under section 164 of criminal penal code should be made, and also sort of the documents in sealed covers should be brought into the notice of the honorable court. And secondly, the investigation, the witness of the headmaster of that school where she studied, and another the question of the person who has been investigated and the cross examination has been made. Next question will be put before the doctors that whether the external injuries have been found on the body of the child or not. In that case, that I am talking about, the child had washed those clothes, and the whether such type of the incident, when the clothes have been washed out, whether it can be proved. Yes, it had been proved in that case, because the external genital had got the injuries, and PV examination report, it has been mentioned that human has been torn out, and the bleeding has been found on the parts of the child, and the swabs collected from that child has been collected. And now the question is that when the child has washed out those that colored salwar, then how can we conclude that the offense has been made? The question is that under cross examination, she admitted that now she has washed the clothes, but even then she could not wash those clothes properly. And when we investigated under the investigated, and prosecutors brought before the court the swabs and the Siemens having the signs of getting those offense has been brought to the notice of the court. Now, next question is that we conclude that this is a gang rape or it is gang rape. Under section 376D IPC, we consider that all those type of the offenses, those are concerned with gang rape, will be brought into the notice of the honorable court, and the trespassers, those have entered the house of the victim, will be brought to the notice under section 450 of the IPC, and section 506 punishment of forcible for criminal intimidation should be brought into the notice of the court, and under section 6 of the protection of children from sexual offense act should be brought to the notice of the honorable court. Now the interconnected sections, those are most important in the case of protection of children from sexual offense act, are that section 10 of Pocso Act, that punishment for aggravated sexual offenses there, that then the additional sections, those are to be considered. Section 363 of IPC, punishment for kidnapping, that section should be included, that should be additionally included in the FIR. Section 342 of punishment for wrongful confinement, and section 354 of assault or criminal force to women with intent to outrage her modesty should be brought to the notice of the honorable court, including section 8 and 10 of section of Pocso Act. Now the question is that whether sections 164 recording of confession and statements of the should be made, and though in those circumstances all those statements are to be made before the judicial magistrate first class, or and those statements are to be brought into the notice of the honorable court under section 75 of Juvenile Justice Care and Protection of Children Act 2015, cruelty of child. If there is a person who was involved in that offense, if he is juvenile, then that should also be brought into the notice of the court, and the sentence in that case could not be extended to 3 years or fine of rupees 1 lakh in that case. Under section 82 of Juvenile Justice Care and Protection of Children Act, corporal punishment, whether it can be made to the child, no, it is not permissible. So all the offences of atrocities under section 3 of punishment of offences of atrocities, the scheduled tribes prevention of atrocities act and molestation should be brought to the notice of the honorable court. That's all. I conclude my lecture in this particular question.
Thank you so much, Rajan, sir. Indeed, it was an honor to have you with us, and you have given us various explanations which spoke about the practical difficulties and the practical beneficiaries, as also while investigating matters which are of relevance to child sexual abuse. I think we've had an interesting session, and if we have any questions forwarded to us, then we will make sure that the same are posted to you, either via emails or anything. And if you could sum up your entire discussion in probably 3 or 4 minutes, that would count as a closing statement of yours, and post that we could probably conclude the program. You could give us your closing statement, sir.
Dear students and all the honorable members of this institution, I am very thankful to all those persons who have been in this webinar, and those were and the students, those were aspirant to taking the exams of judiciary in the next session. I will pay my gratitude to all those persons, those have joined this class and give their valuable time to me. I am thankful to the institute that has given me the opportunity to provide the knowledge to the students and all those the persons who have attended the seminar. Thank you.
Thank you so much, sir. Indeed, it was an honor as well to have you amongst us. And to formally propose the vote of thanks, I would request Anime sir, the founder of De facto Jill, to just probably render 2-3 lines about the entire webinar, and then we could perhaps conclude.
Hello, everyone. Thank you, sir. आज जो वेबिनार का मुद्दा था, ये बहुत ही सेंसिटिव मुद्दा था। सर और मैम ने इसे बहुत अच्छे से निभाया है और अभी मैं ग्राफ आप लोग को मेरी टीम शो कर रही थी। उस ग्राफ में आप देखेंगे तो सेक्सुअल एब्यूज या फिर सेक्सुअल असॉल्ट से जितने लोग पीड़ित हैं, क्या ये होना चाहिए? अगर आप 18 साल से नीचे के एज के बच्चों को देखेंगे तो उनका परसेंटेज है 15%। उससे ऊपर देखते हैं तो 38%। उससे ऊपर जाते हैं तो ये परसेंटेज घटता है और उससे ऊपर जाने पे फिर बढ़ जाता है। तो क्या ये उचित है? तो अगर हम सभी इस प्लेटफॉर्म के माध्यम से किन्हीं को और जितने भी हम लोग टीम हैं और सर हैं, इनके माध्यम से लोगों के पास अगर जागरूकता फैलाने की कोशिश कर रहे हैं या फिर फैलाना चाह रहे हैं, तो एक सपोर्ट चाहिए आप लोग का कि ये जो सेशन है, इसे बहुत से लोग मैं देख रहा हूं कि अभी वेबिनार चल रहा है और वो लोग मैसेज कर रहे हैं कि मुझे सर्टिफिकेट कब मिलेगा। तो ये सर्टिफिकेट के लिए वेबिनार नहीं है। इसका मेन मुद्दा ये है कि आप लोग चीजों को समझिए, दूसरे को समझाइए और जो ये अपराध हो रहा है इसको अब यहीं पे रोकने का प्रयत्न कीजिए, अब नहीं, क्योंकि बहुत हुआ। अब हम लोग यंग हैं और हम लोग यंग जनरेशन को चाहिए कि ये किसी भी तरह रुके। और इसमें माननीय सर ने जिस तरह से आज चीजों को समझाया है, इससे समझ में आ रहा है कि अपराध करने वाला ये नहीं देखता कि वो एक छोटी सी बच्ची है या छोटा सा बच्चा है। सर ने बहुत अच्छा एक उदाहरण दिया कि मुश्किल से वो 3 साल का बच्चा या बच्ची की क्या गलती है। ऐसे अपराध हर दिन होते हैं और लोग सामने नहीं आ पाते हैं। इनके लिए हमारा एक हेल्पलाइन नंबर है। किसी भी बहन, महिला, किसी को भी कुछ प्रॉब्लम है, आप उस हेल्पलाइन नंबर पर कॉल कीजिए। ये हेल्पलाइन नंबर को अटेंड करने के लिए महिला लेडीज के लिए स्पेशल लेडीज कॉलर हैं जो आपकी हेल्प करेंगे। और सर से मैं आग्रह करूंगा कि नेक्स्ट सेशन में हमारा सेशन को फिर से ज्वाइन करें और जो इंफॉर्मेशन आज दिए हैं इसी तरह से आगे भी देते रहे।
थैंक यू सर।
थैंक यू।
Certainly join.
Thank you so much, sir.
Thank you, sir.
Anime sir. So, yes, would the other panelists like to say something?
Participants are requested to fill up the feedback form.
Right. So the feedback forms and the certificates, all matters governing these two elements will be communicated to you shortly via the WhatsApp groups and the Google Classroom. However, if you have any other queries or anything else to convey to us, you're free to contact us either by the phone numbers available on the event poster or via email or any other means which you are convenient of. You could even get in touch with us personally. I think having said this, I am also thankful to Rajni sir and Siddhi ma'am also in her absence for making this a very successful event, and of course Dr. Keval Patel too, who unfortunately couldn't be with us. Last but not the least, I would also like to thank my colleagues Nayanmoni Datta, Rohit, and Priyanshi for being supportive of the team, and also the participants for their due diligence and patience throughout the entire webinar. And a lot many others who have joined us through watching the video over YouTube and other social media platforms. Thank you so much. With this, we conclude the webinar officially.
Thank you, Amulya. Thank you all too.